So we have been talking about what the platform economy is a lot during these days, and we had also results from surveys that show many interesting things about the platform economy and how platform workers fare into the labor market. But I think that from the legal perspective, we should still discuss what is relevant. So what is relevant for lawyers when we discuss about the platform economy? Because surveys normally give us a picture of how much workers are paid. Is this an additional income? What kind of jobs these people had before? Where are they going, etc., which is all extremely interesting for policy, but in legal terms, it's totally irrelevant. It's not relevant to know whether somebody works as a side job or it's or as a personal form of income. And actually, this is a big part of the platform's narrative. You shouldn't regulate this because, after all, this is people that don't depend upon this job. They don't need this job. They are just students that moonlight, etc. Which, first of all, is not true. But even if it were true, it wouldn't be relevant in how we should regulate that, because regulation of labor market is not just about the motivation that drives you into work, but also protecting the labor market more in general. And so this is one first point that I would like to make. Now, when we talk about platforms from the legal perspective, I mean, Rina and Michele already said a number of very interesting things on this. We normally have a model that is platforms employing independent contractors, self-employed people that normally are excluded from the vast bulk of labor protections. In many countries around the world, they don't have access to the minimum wage, they don't have access to working time regulation, but in many cases, they also don't have access to fundamental rights such as the right to collective bargaining and the right not to be discriminated against at the workplace. What the platforms do is basically engage these people as independent contractors normally, but in some cases, the platforms that we all discuss about hire people as employees depending on the national legal framework. For instance, in Germany, Foodora hires their riders as employed workers, waged workers, under the so-called mini-jobs schemes. And so, in some cases, actually, you see that the platforms hire people as employed persons, and we should actually not fall into the idea that employment cannot ever play a role, employment law and employment relationship, because in some cases, it's even the same platforms that hire people as employees. So to say this model of work is totally incompatible with employment, it's a sham, because they are the first that employ people through employment contracts where the national regulation obliges them to do so. Now, why I think it's relevant to look closely to this self-employment idea? Because normally the platforms say that they only match the demand and supply of work. So it's say we are basically function as a sort of yellow pages. You want some work to be done and you find workers, and that's what happens. Actually, from the legal perspective, that's not true, because in many cases the platforms actively intervene in how the work needs to be done, how much time you need to employ for a certain job, what kind of outfits you should wear, how you should treat customers, so you should greet customers. In some cases, when we talk about digital work, some platforms take screenshots of workers' screens to show the clients that they're actually working when they are paying the workers an hourly wage, an hourly pay. And they also use rating systems, so they ask customers to rate the workers and use this rating to discipline the workforce. And use algorithms and the metrics that the algorithms take from the job, how fast you are when you deliver something around the city, or if you are an Uber driver, for instance, how fast you complete a certain job, how fast you brake, etc., etc. Now, all this resembles much closely traditional employment and what traditional employers do, rather than what an independent contractor and their principle do in a self-employment relationship. And I think this is quite important because, as we have seen, Michele and Dina already went into this, we have seen litigations everywhere around the world because the workers say, well, wait a second, I mean, I'm classified as an independent contractor, but actually I have not any saying in how I do my work. I don't even have any saying normally in how I charge customers. Normally it's either the platforms that allow, it's either the platform that fixes the pay, so like if you're a rider or driver, etc. But even when it's not the platform and it's the customers, it's the platform that allows customers to unilaterally fix the pay. So they also intervene. This is a way, as Janine would say, of regulating the relationship. It's not true that there's no regulation. It's basically self-regulation unilaterally decided from the platform. Now, again, people around the world start to challenge this idea that they are all self-employed. And why that is important? It's important because, as I said, if you're an independent contractor, you don't have access to fundamental rights and to basic labor rights such as the minimum wage, working time, etc., etc. And so people start complaining and say, well, actually, I should be protected. And they file lawsuits all around the world. And in many cases, they lose these lawsuits because the judges fall into a very shrewd narrative picture from the platform that these people are flexible, that they can decide whether to go to work or not and when to be at work or not. They have flexibility of working time. They can decide if and when they want to work. And normally, judges go for it because we have tradition, but it's more of a sort of path dependency because actually you don't find necessarily this idea that you cannot be flexible in working time as an employee, but there's this sort of path dependency of associating employment with 9-to-5 standard employment relationship. But actually employment as a concept can be much wider than that. I am a law professor, I am employed, nobody knows where I am today, and I didn't have to ask a permission to be here in Rome. Nobody bothers, basically. I think the more I stay far from the university, basically, the happier they are. But actually, there's a lot of flexibility also in regular employment. So the idea that flexibility, I know that President Sakia's first-hand experience, but actually, you can be flexible. You can have a flexible working time, even if you are an employee. Flexibility of employment, the fact that you can decide when to work, doesn't necessarily mean that you don't need to be protected. And doesn't necessarily mean that you cannot be protected already under existing regulation. This idea that we should only give centrality to this factor of being flexible when you work or not is wrong. It's wrong in legal terms, but also it's also wrong in policy terms. It doesn't make any sense to exclude workers from the right to collective bargaining because they are flexible in working time, when they have no saying whatsoever in how their prices are fixed, for instance. Now, in other cases, but in many cases, the workers lost these lawsuits, but there are also examples in Spain and in Belgium in which actually their lawsuits were successful. The judge went beyond the idea that since you are flexible in when and you can theoretically decide when to work, you don't need to be protected under traditional employment law. And I want to add something on this. Until we know how the algorithms work, we don't know if you're actually flexible. Because it's true that nobody tells you you should be there in this place at this point of time, but we don't know if the algorithms penalize people that have an irregular schedule. Because we don't know how the algorithms factor this instability when they decide how to assign work in the future. And workers, when they answer to survey, they say, well, yes, maybe we don't have an obligation to show up, but actually we know that if we don't show up, we risk to be penalized, we get a lower rating, and we don't get any jobs in the future, or our shifts are lost for the future. So until we exactly know and we have transparency on how the algorithms work and how the work is distributed, and this is not just about working time, but it's also about discrimination. We don't know if, for instance, customers rate me badly because I have a very marked Italian accent, for instance, and they don't like it. And if they do that and they rate me poorly because I am Italian, there's no way of knowing if that's factored into the algorithm. So we need to have transparency on how the algorithms work before taking for granted that there is this flexibility. But even if there was this flexibility, it wouldn't make sense to exclude people from fundamental labor protection only because they are flexible in working time, when during their shifts they are subject to a stringent control and stringent subordination. Now, what can you do? Basically, what we should do is to have transparency of the data. We should ask the platforms to share the data and actually to negotiate how the algorithm works with the social partner. This is the first thing that I think needs to be accomplished. Secondly, we should not tie protection of employment only to flexibility. And if there's a path dependency of courts that go and identify employment as a 9-to-5 job, we need to pass reforms that break this path of dependency. And I mean, this was the case, this was basically what was attempted in Italy, and I talk of path dependency because actually, and as Michele has said before, the judge in Turin read a provision of the Jobs Act that basically everyone thought it could go in the direction of protecting at least riders and gig workers at large, and interpret the provision as if it were useless. The judge says in the judgment, this is a useless provision. The lawmaker was wrong, and I'm not going to take this into account. Which, because we have a path dependency of judges that think that only people with a clear schedule can be regarded as employees. And we need to break it down, because actually in our definition of what an employee is, Article 2094 of the Italian Civil Code, we never talk about continuity of obligations. Now, there is a lot of jurisprudence and case law that has developed this concept of continuity, but this was done in a period in which, during the shifts, there was not the close subordination that now digital tools ensure platforms have. So it doesn't make any sense anymore to refer only to flexibility on this. So we should go beyond this idea that a flexible worker cannot be an employee. We should ask for transparency in algorithms, and we should actually totally make sure that employment law has nothing to do with flexibility, especially when it comes to access to fundamental rights, especially when it comes to access to discrimination rights, to union rights. The fact that you are a flexible worker shouldn't prevent you from being protected under labor laws. And I stop here. Thank you.